Okay, so good morning and welcome to this fourth webinar on data protection and journalism. Today we focus on GDPR and the handling of personal data in journalism within the European legal framework. Today we have again Iñigo from the University of the Basque Country as a speaker. So good morning, Iñigo.
Good morning.
Thanks for being with us today. And while his presentation will unfold, I will put in the chat a couple of links. One will be to our draft handbook on data protection in journalism. And another one will be a link to a survey, to sort of quiz we have drafted to test your knowledge on data protection in journalism. And another one is we are drafting another survey that I will send you by email in the next days, just to ask you to evaluate our handbook or to make suggestions on how to expand it. So yeah, wait for my email in the coming days. And before giving the floor to Iñigo, I just remind you that you are free to ask questions to our speaker. So after his presentation or during the presentation, feel free to raise your hand and intervene to the debate. So let's keep it as interactive as possible.
Yeah.
So, please go ahead, Iñigo.
Okay. Yeah. Thank you so much, Federico. Indeed. Yeah. Let's try to make it as interactive as possible, as dynamic as possible, because it will be much more interesting for all of us. So I will try to make a quite brief presentation of what it is, the handbook for journalists and the GDPR and so on. And then you, of course, you could make some questions, or we could talk about different topics. I mean, I'm totally open, you know, to whatever might come to your mind. And if I really can answer your questions, I will really try to. So let's start for the very beginning. Let's see what this is all about. And first idea, I think that the most interesting thing is that first, thank you, Federico, for organizing this. This is part of the Panelfit project, and I will just dedicate 1 minute to explain you what this is all about. Panelfit project is a new funded project. It was funded by the EU Commission. It's a project that started like 3 years ago, almost right now, and will be finished at the end of April 2022. And it's a project that is mainly devoted to analyze the issues raised by the new data protection framework at the EU level. For those who are not familiar with it, the EU approved a new regulation on data protection in 2016. And at the present moment, we have some new tools that are on the process of being approved by the EU. Those are mainly the Regulation on Artificial Intelligence, the Data Protection Governance Act, and the Privacy Regulation that will probably introduce some particularly important novelties to this regulation. So keeping this in mind, our project is mainly aimed at helping all of us understand how this new regulatory framework work and try to help us do our work in a better way. I mean, in a way that really combines the respect to this data protection framework with the real things that we have to do. In your case, for example, the idea that you will be able to inform society in a nice, adequate manner. So that's more or less what we have, and this is what Panelfit is doing with producing a set of outcomes that will be very useful to this proposal. So I will be just trying to introduce you what we have right now and how this new regulation might be related to journalists and the work that you do in your day-to-day life. So just to start by the very beginning, we have a first very important fact, that is that the on May 25, 2018, the European General Data Protection Regulation came into effect. So it's been 3 years. Sorry, I said like 5 before. So it's 3 years that we have this new regulation. This is a quite impressive document with 99 articles that are divided into a lot of paragraphs and so on. And there are also lots of recitals, like 173, that are aimed at facilitated interpretation of the articles. This is mainly what we have right now. And in order to understand how this works, I think that the power metaphor is it's quite interesting. The power metaphor means just simply that information is power. So whenever we are sharing data, we are just unveiling some things about that. So the point is more or less that data subjects, like the ones to whom information is related, should have the power to manage this information. So that's more or less what the GDPR does. The GDPR is mainly related to the idea that you have to preserve this kind of power, and of course we all know that sometimes this is impossible in the world where we live. So the idea is that whenever you share your data, there must be some warranties for you, and you should always, preserve some specific rights. So the basic structure of the GDPR is that only some processing for certain kind of purposes are allowed, and then only, or those processing is only possible under certain conditions. So that's more or less how it works. So the idea is that in general, the processing of personal data is forbidden unless it is conducted for legitimate and lawful purposes. So purpose is more or less the objective, and indeed legitimate and lawful means that really those purposes work well with the spirit of not only the regulation on data protection, but the regulation on fundamental rights at the EU level, but also means that you really have found a kind of legal basis that allows you to process those data. And at the GDPR, there are like several conditions that have been included, even though when a processing is lawful and so on. So the idea, what we have right now is, for example, that first, we must make sure that the controllers, I mean, those ones who are responsible for data processing, the ones that are really, providing that, are really accountable, meaning that they are fully accountable for the whole processing activity. So they will be the ones that will really have to justify everything and provide you with warranties about what's going on. So data subjects in general are empowered through what we call the data subject rights. This means this involves a kind of limitation of the gain power to what is minimally necessary to fulfill the legitimate purposes of any processing. So in this way, there should be a kind of balance power between you and the responsible for the data processing. Even more, the GDPR introduced the idea that a supervisory authority will help you to implement those rights if need be. And the idea is also that the controllers could also use those data for the purpose that have been declared as legitimate purposes. So that's also a warranty for you that your data will not be used in a way that you have not really approved in general. And so there's also a kind of protection to your investments and asset, meaning that your data will be protected and you will be able to recuperate them if need be. And of course, there's a prohibition of processing that fails to be fit for those purposes. So that's more or less what we have. Keeping this all in mind, and whether we know that there should be a legal grounds for the processing, and that some principles must work in all type of processing and must be implemented. There's a very specific clause in the GDPR. That is what we usually call the journalistic exemption. This has been described or included in Article 85 of the GDPR. That is particularly important in the field of journalism. What this article states is that mostly member states shall, by law, reconcile the right to the protection of personal data with the right of expression with the right to freedom of expression and information, including processing for journalistic purposes. So the idea is more or less what you have in that is that member states are really, and in theory, obliged to introduce some kind of national regulation trying to introduce a balance between this, between the necessity to provide information to citizens, that is to do the work that journalists usually do, with need to preserve kind of data protection issues and so on related to the data subjects. So there are a lot of exceptions that could be introduced to the general rules of the GDPR on the basis of journalistic exemption. And this could include, for example, some particular limitation on the principles and on the data subjects' rights. So those are kind of strong exemptions. And the idea is that every country, as I was saying before, should introduce their own legal framework on this, and they shall notify the commissions the provision of its law. Okay, so they are also obliged to do so, and they should do that without delay. Okay, so the idea is that the EU Commission wants to be aware of what's going on in all member states, and the Commission would like to know what are the new regulations that are being approved in each member states. Of course, at the present moment, some member states are doing so and some others are not. So the point is more or less that this kind of journalistic exception was included in the GDPR as a kind of intermediate solution, as a kind of solution that should serve well to alleviate the tensions between freedom of expressions and the right to data protection. And we all know that this kind of rights, fundamental rights, will always be somehow in conflict. So the idea is that we're just trying to find out what should be the best way to balance them. Of course, this is often different, or there are some kind of different traditions in all member states. That's why more or less it's finally at the end of the day remains at the kind of hands of the member states instead of being a kind of common ground at the EU level. So this is more or less what we have right now. So one must always think about the roles to be full in the journalistic environment from a double perspective. So somehow you get this kind of series of rules that are embedded in the data protection regulatory framework that in practice should be followed. But on the other hand, there can be these certain differences between member states. Of course, this doesn't mean that member states can do whatever they want. Indeed, in practice, they should always provide good reasons to introduce the concrete exceptions that they would like to introduce. So it's not so easy to do things in a way that really doesn't work with the GDPR. We should always keep in mind that the GDPR is a regulation, so countries cannot really develop a kind of national regulation that is against this common EU framework. But of course, this on the other side doesn't mean that they cannot introduce some concrete differences between themselves. And in practice, indeed, we have found some very interesting differences. For example, in Bulgaria, there was an attempt to introduce a national regulation and a national approach towards the implementation of Article 85 that was declared unconstitutional by the Constitutional Court because it could create a risk of arbitrary interpretations of some essential concepts, such as, for example, freedom of expression. Indeed, the main issue with that regulation was that it opened the way for the Commission for Data Protection to have an unpredictable power to interpret it, and not necessarily in the public interest regarding pluralistic information about the policies and activities of the government. This was a kind of, I dare say, preliminary control of the Constitutional Court against a kind of regulation that could work against journalistic approach. I mean, against the freedom of expression, against the work that usually journalists do, that is to try to provide information about what a government's doing. But this was a kind of successful monitoring of a new law. Instead, in Romania, things work in another way. And the thing that happened in Romania is that the data protection regulation has been criticized because they were really threatening journalists with severe fines because of some of the information that was published in some concrete internet websites. Those were the way that this happened was that the data protection regulation sent a kind of a series of questions to journalists who authored an article about a corruption scandal involving a politician and his close relationship to a company being investigated for fraud. So the point is that this kind of conduct could serve quite well to introduce a kind of controlled monitoring and to reduce the freedom of expression and the role to be developed by mass media in a quite arbitrary way, meaning that a government could try to erase any kind of criticism from the mass media by applying data protection law. And this, of course, is a scenario that nobody is willing to be implemented in practice. So we all hope that in the future this we will be able to find a nice balance. Of course, it is true that some countries such as Sweden more or less are considering that maybe the Article 85 is giving too much space, for example, for exemptions to the member states. And in that sense, the old data protection directive was better than the regulation. So it might happen, and it's a kind of criticism that we should all bear in mind. So in order to give you some tips that could work well with your day-to-day work and what you get to do, well, I will start for a very essential type of advice. First of all, you should always consider that in general, whenever you are processing personal data, the GDPR applies. So you, as a journalist, you will have to start by finding a nice legal basis to justify that the data processing is lawful. And there are three main candidates that you could use. Those legal bases are described in Article 6 of the GDPR. The three that really applies to your situation mainly are those ones that we could consider or we could describe as consent, public interest, and legitimate interest. Consent is the kind of legal basis that it's maybe the most traditional and the one that usually works quite well with most data processing. This has to do only with the data subject, the one that information is linked to provides consent. Of course, this consent needs to be free and needs to be the kind of consent that is also specific and informed, meaning that the data subject knows perfectly well what is the type of purpose for this processing and the consequences that this might bring in so many ways. So the idea is more or less that you should provide them with nice information, and if they give the consent, you could start processing those data. Of course, we are all aware that this this is not really the situation that happens in most, or at least in part, of the journalistic world. Most people indeed will never give their consent for some kind of information. That's why there are two additional bases for processing, or legal grounds for the processing that apply. The one is the legitimate interest. The idea is that the processing is necessary for legitimate interest, provided that it will not, this processing will not cause unwarranted harm to the person concerned. So the idea is more or less that if you are working, for example, to a private media, a legitimate interest does not apply to public institutions working as public institution as such. But if you are working in a private media, you could always say that you got a legitimate interest to publish this information. And if you consider that this interest is prevails against the interest that the data subject that might have, then you could publish this information. Of course, this legitimate interest basis is very much related to the third one, that is the public interest. That is the most common legal basis for most of the data processing in the journalistic arena. Public interest simply means that the data can be processed if it is necessary for the performance of a task carried out in the public interest. The idea is that in general, you could perfectly justify data processing by saying that this information is of particular relevance for the public, and so even though the data subject does not agree on that, if we don't have the consent, we could just follow up with the data processing, because this is for the public interest purpose. And this will work generally well. However, even though you get this kind of legal ground for processing, you should always keep in mind that the purpose limitation and data minimization principles will always apply. What does this mean? In the case of purpose limitation, it means that personal data shall be collected for specific, explicit, and legitimate purposes, and will not be processed or further processed in a manner that is incompatible with those processes. So that's more or less what the principle says. So what you need to keep in mind is that you cannot use those data and keep it in your record for purposes others that justified the processing, unless you have a basis that serves as a ground for new processing. So I know, and I'm quite well aware, that usually journalists are always willing to keep the information and to keep information about the sources and so on. And sometimes it is even compulsory. I mean, in some countries, you need to keep those data on your records. But at some point, you need to be aware that you could not really preserve this data forever. I mean, there should be a time limit, okay, and you should be aware of that. So the point is more or less that if you continue keeping those data, you should have a good reason that justifies that. And I don't think that the reason could be that you just keep those data because in the future they might be helpful to you. You need to keep a quite solid reason on that. And the data minimization principle, on the other hand, says that the personal data that you gather shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which those data are processed. So the idea is that you must have enough information to do the job, but shouldn't have anything you really don't need. So the point is more or less that this principle takes account of your purpose. So the idea is that in general, when you are practicing journalism, you take a lot of data, you get a lot of that, and but some of those data will not be relevant for the information that you are providing. So the idea is that if you are willing to publish an article that is related, for example, to fraud, and some politician, performing a kind of fraud, and maybe you also know a lot of things about the sexual life of this politician, the point is that you don't really need this information for denouncing a kind of fraud. So it will not be justified that you are using this information about sexual life if it is not connected with the purpose of the information, especially because it relates to, of course, to the to the private life and special categories of data. But in any case, you should not process any kind of data if this is not really needed for the kind of information that you are willing to provide. So that's more or less what you have. So you should also consider that the principle of accuracy of the data is fundamental, because according to Article 5 of the GDPR, personal data shall be accurate and where necessary kept up to date. Every reasonable step must be taken to ensure that personal data are inaccurate, having regard to purposes for which they are processed, are erased or rectified without delay. So we all know that accuracy is both a principle of the GDPR, but also a key value of journalism. Journalists must provide accurate information. If this is not the case, this is not really good journalism. We are entering in this kind of, disinformation arena if it is not really and directly misinformation. So the point is that in general, you should check the facts. Okay. So the idea is that you must make sure that what you are really publishing is accurate and the facts are right. However, we are aware that sometimes some stories are urgently in the public interest, and you get a short deadline that makes complete accuracy check very difficult. So even with the use of any exception, you will still need to show that the proper thought was given by someone at an appropriate level to what checks might be possible, where the publication could be delayed for further checks, the nature of the public interest at stake, and that the decision to publish was therefore reasonable. So my tip on this is that if you are in this kind of situation at any time in your life, please try to consult with someone who is there and who is maybe more experienced, who have a better vision, and who is more objective. Because to my experience, most of journalists who are willing to publish a very, I dare say, public opinion attracting publication are really willing to do so. So someone who is not signing this article will probably be much more objective in order to ensure that whether this this fact checking is possible or not, or to what level it should be brought on, something like that. So that's more or less what you need to keep in mind. And of course, you should always be open to the need to rectify the information if those people, data subjects that were affected, are telling you to do so because it is not really accurate. So you should always provide some room for rectification. Then storage limitation is more or less what I told you before. So it is that you should store the data in a form which permits of identification of data subjects for no longer that is necessary for the purposes for which the personal data process. So the idea is that more or less you shouldn't keep those data for too long. And if you are keeping data, please do whatever possible to try to avoid that. You are not keeping too much information, and try to keep that in the most possible secure way, so as to try to avoid data breaches or maybe the impact of these data breaches on the data subjects. And then you also have the integrity and confidentiality, meaning that the data that you are storing is sensitive, so please try to keep them safe. Okay, use the procedures and security protocols. That's more or less what I was saying you before. Here, the main problem that we have is that when you're working in few organizations, this is quite simple, because the media companies that have the protocols, maybe they also have some security departments and so on. So the main problem is that when you are not working on this company, so if you must be somehow implementing this kind of measures, so maybe some technical help could serve you well. So that's more or less what happens to you. So always keep in mind in any way that, of course, the sensitivity of data will probably make a difference in the type of measures that you have to incorporate to that. And then accountability, of course, the controllers shall be responsible for and be able to demonstrate compliance with with everything that has to do with data processing. So the point in more or less on that is that you need to keep records on what you are doing, depending on what the type of processing. You will probably have to perform a data protection impact assessment, depending on what you are doing. And of course, if you're working in a huge company, this will be probably done by the company as such, meaning the mass media. In general, some of them have already developed protocols to do so. Codes of conduct in this kind of organization are always recommendable, and it really simplifies your life. But in general, you should always be aware of that you should keep records of what you are doing with those data. And the idea more or less is that here I am showing you a kind of protocol that would serve well for different purposes, such as, for example, the guidelines on safeguarding privacy in the media. Now that more or less gives you some types of what you can do or not. So I don't think that I will talk any longer. I think that it makes more sense that now I give you back the floor so as we could introduce some kind of questions and comments or whatever, Federico. So thank you so much, everyone, for your attention. And now I will be just, looking forward to receiving some feedback from you or questions.
Thank you very much, Iñigo. It was very interesting and very clear as always. And I see that there are the previous speakers of the two webinars we held in the past days. So very happy that they're here among the audience. So of course the floor is open to you as well if you have particular questions. Otherwise, the same goes with the other participants. Simply raise your hand or unmute yourself and feel free to speak if you want.
I think Jose Antonio is really, trying to fight against the temptation to make a comment, but feel free, Jose Antonio. I mean, if you're willing to introduce some tips, that will be much welcome. Because he's suffering, Federico. I know that he's suffering. He's really willing to make a comment. So please, Jose Antonio.
He's always the most interactive participant we have, also in the monthly chats. So
yeah, we all know. So Jose Antonio, go on with that. Make your comment.
Thank you for allowing me to convince the temptation. Just to share a reflection, I don't know if you agree on that. I would like to know and debate maybe. I would say that the presence of the GDPR does not alter the previous either national or European legal doctrine on freedom of information and freedom of expression, as you shared with those pronouncements in Bulgaria and Croatia, I think. So what I would like to highlight is that the historical relevance or the presence of any information that can be called as new would leave behind the GDPR. I mean, if I have any important information, the GDPR principles would not be applicable since I have a relevant new or any historical information. Do you think so, or maybe I'm losing something?
No, you are losing nothing. I mean, the tension between the the need to publish some relevant information and privacy is classical. I mean, it's an historical challenge that we are facing, and I don't think that the GDPR introduced nothing new on that. I mean, the point is that they just said something like, we all know that this happens. We will just try to introduce this kind of exception just to recognize that this could be very different in the member states, and in practice it is. I mean, in some countries, the need to ensure that the mass media are really, able to control the governments and to provide us with good information is very high, while in other countries this is not the case. So it's very difficult for the EU as such to try to impose a common approach to this, to the way in which we solve this conflict. So what happened in practice is that they more or less they gave some essential tips on that, and that it left it all on the hands of the member states. So in so many cases, this is a perfect example of why the GDPR is a kind of directive-like regulation, in the sense that it only gives, you know, some common tips and then say, okay, and then do as you wish. The only condition that really applies, but it's also very common to a directive, is that member states should notify the Commission of what they are doing. And if what they are doing really goes against the regulation, so it's much easier for the EU institutions to introduce this kind of change, or at least to tell member states, hey, you have to rectify that because this is against an EU regulation. And more than this, the key factor, in my opinion, is that since the regulation is directly applicable, if any court at the member states level could really you know, apply for the regulation in order to beat a kind of a national law that is against the regulation. So what is new is that the EU is providing the courts at the member state level with an essential tool in order, you know, to try to avoid the kind of regulation that really work against freedom of expression, for example. So this is the only thing that is really new, that since this is a regulation, a court could directly use this tool. This is the only new thing, in my opinion. So that's what we have.
I will thank you, Iñigo. I would like to intervene as well. A wonderful presentation, as always. I would like to add as well that with the GDPR, I think the traditional conflict between freedom of expression and privacy or reputation. One thing that changes, I think, with this regulation is that in the past, the ones that should always balance these two rights were the courts, the judicial power. Mm-hmm. But with the GDPR and with on the browsers and the internet, the first ones that will normally strict this balance between these rights will be the browsers with, in this case, I'm talking about the right to be forgotten, are the ones that will, first of all, just balance these rights, just saying if a content should be erased from the browser or shouldn't, because it's an exercise of the right of information or the right of freedom of expression. And secondly, we will have the data protection authorities that are the ones that will decide in this matter. Of course, in both cases, will be the potential appeal to the courts. So maybe the courts, as always, will have the final word. But I think this is an important transformation, how these rights are affected by private organization and data protection authorities as well. So I just wanted to add that.
No. Yeah, thank you. Indeed, I guess that you are right somehow in some points. First, I will start for my disagreement. My main disagreement is that, in general, when we introduce this idea of data protection agencies that are the ones that should more or less, intervene on this creates a danger. Is that generally data protection agencies are linked to governments. So it's they are a splendid tool for governments to avoid freedom of expression. They will just say, no, you cannot gain access to this data because this, data protection issues. That's something that, for example, in Spain has happened with in the case of transparency and the government, that the government is saying, no, I cannot reveal this because this goes against data protection, and that is really, one of the most crazy things that really might happen. But indeed, some governments are just saying, no, I will not tell you what I've done with public funding because this goes against, data protection issues. it's a typical, you know, perversion of the system in so many ways. So at some point, I guess that this is quite nervous. I mean, this is quite, you know, something that really makes me a little bit, you know, aware of what might happen if we give too much power to these data protection agencies that are administrative tools, so controlled by governments, at least in some countries at the EU level. And on the other hand, yeah, I think that you are right, that one of the things that is good on that is that in general, at least companies are aware that they are responsible for data processing. They are accountable. And so though they are the ones that really need to justify what they are doing with your data. So at some point, this is very good because they should be responsible for that. And in the case, for example, of journalists, I guess that this could be very, very interesting in order to make sure that when they are providing some kind of information, this is really needed for the intention that it's researched. And I am thinking on those cases, for example, when they start just sharing information, showing images and so on, when this is not really needed for the kind of information. But we all know that if you expose some concrete images, the impact of the information will probably be much stronger. But those are not needed, and really, you know, create an issue for those data subjects. So one of the good things that we have right now is that probably those companies or the mass media will be aware that they need to justify those data processing, and they might be a little bit more careful when making decisions about what is exposed to the public opinion and what is not. So in that sense, I think it's better because at least we have now a new mindset that is like, okay, privacy and data protection is important. You will be accountable for that. We have this kind of data protection by default that is in their mentality, and you really need to work with that. So in that sense, I think that the new regulation works very well for trying to impede the most important, you know, or the most terrible facts that have happened sometimes in the journalistic arena. So that's it.
Yeah, thank you, both Jose and Mario, for your questions. I was just thinking in the last part of your presentation to the practical and technical duties that these tips imply. And now I'm thinking not to the media organization, but rather to freelancers that sometimes have to work with their laptop and like trying to cope with the day-to-day stuff that is implied in the journalistic profession. And so I was thinking about both the importance of being aware of all these scenario and all the things they should do or shouldn't do, and also the importance of the networks of journalists that, I mean, can help them work in a lawful manner. And also I wonder if there are also platforms like technical solutions that, I mean, if I am an investigative journalist and I have a leak of data from a political subject, I'm sure that I'm storing that data in a safe manner, safe place, etc. So also this is, I mean, maybe it's not that the GDPR introduced something very new on this, but maybe it made it more clear, and yeah, and it's an interesting aspect, I guess.
Indeed, I dare say that one of the things that happens with the GDPR is that, of course, the life of freelance gets complicated because you could be fined by by a data protection authority if you are not using those data in an adequate way. I think that in general, I mean, we should not consider directly that the mere fact that it is not so easy for you to implement the GDPR means that your responsibility will be lower than if you are working with a huge company. That's one of the the main things that we have. Of course, I know that it's much more difficult for a freelance to work with this than for someone who is working, I don't know, in El Corriere della Sera. We all know that. So precisely, and due to the fact that you are perfectly right, I guess that it's even more important to try to find out what could be the best way to provide with individual freelance journalists with the best tools in order to work well with that. And of course, I think that collaborative work will be the best thing. I mean, if you're isolated, the work will be terrible for you. If you have a kind of a network that is helping you with at least some very easy to understand tips, that could be a good idea. And at the end of the day, we should always keep in mind that you can do some things that really don't work so well with the GDPR in your day-to-day work, but it's pretty difficult for you to do terrible things. So, for example, if you get an idea that's something like, oh, I got this splendid video about this politician who is, and his, I don't know, his sexual life, and I will post that in my website and so on. Is that because you really know that you are doing something wrong? You really are aware of that. So I guess that the most terrible things is, that you will always find an alarm on you. And if you don't have it, it's maybe that you are missing something really important at the faculty or anything like that. We all know also that there are lots of people who are supposedly journalists while they have never attended the faculties and so on. So those are the type of people that say they could do the most terrible things. Yes, indeed, they could. So in practice, what we need to tell them is that please take care of data protection issues because they are important. And that it could never be said that the mere fact that you were not aware of that will save you. This is essential. I mean, saying sorry, but I mean, we all know more or less what you shouldn't do. Of course, you could make small mistakes. We all know that. And for example, you have some tapes recorded like 20 years ago, and you still keep them. And someone could steal them and publish them in a website, and then you could have an issue on that. Might happen, but most probably this will not be an essential issue, okay? And your responsibility will be minor in so many ways. You have only been, you didn't care so much about that. So there's a problem with the storage principle and so on, and you will have some issues, but it's not the same that when you are publishing this type of tape in a website. So I guess that the most essential things are something that's somehow common sense. And on the other hand, I guess that collaborative work would be essential, especially for press associations and so on. That should be the ones giving the tips. And I guess that, of course, one could always think about organizing this kind of training courses or anything like that. That brings you no more than 1 hour, really, as we are doing today, and there will be lots of records of that. So maybe somehow, Federico, we are doing this right now, and any freelance could,
hopefully,
could download these videos and make sure that more or less they are doing things quite right. So that's more or less what I can tell you. But of course, I'm aware that the effort will never be the same.
Yeah. So thank you very much. If we don't have further questions,
we could close.
I will say goodbye.
Okay.
And okay, so thanks again, Iñigo.
Thank you, Federico.
Yeah, see you in September, because the Panelfit activities for journalists don't end up here. So we just take a break for summer, but we'll be here again. So thank you, goodbye.
Thank you, bye-bye, everyone. Thank you so much, bye.